Theory doesn't win trials. This does. I lost a case earlier in my career that I should have won. I had it won, according to the law. The judge knew I was right, but the jury went the other way. And I didn't understand why for years. It was something nobody in law school ever taught me. The difference between legal theory and a trial theme. And if you don't know the difference, you're probably making the same mistake I did. Now, I've been a trial lawyer for over 20 years, and I've tried more than 40 plaintiff personal injury cases. And I'll tell you something that took me way too long to learn. Knowing the law is the bare minimum. It gets you in the courtroom, but it doesn't win you the verdict. What does win, most young lawyers don't even know about, because nobody teaches it. It's your theme, not your legal theory, not your cause of action, not negligence, breach, causation, damages, all that stuff. Here's what I'm going to show you in this video. First, what legal theory actually is and why it's necessary but not enough. I'm going to tell you what trial theme is and why jurors decide on a theme before they even think about legal elements. And lastly, I'm going to show you two different lawyers handling the same facts using theory and theme. And you'll understand why one of them wins more often. And if you stay to the end, I'm going to give you the fastest way to find the theme hiding inside your current case. But before we get there, let me answer the question I know you're already asking. If theme is what wins, does legal theory even matter? Yes, absolutely. Legal theory is how you survive. It's what gets you past a motion to dismiss. It's what keeps the judge from directing a verdict against you. Legal theory is like your ticket to get to trial. Legal theory is for the judge. Theme is for the jury. And the jury is the one writing the number on the verdict form. Now let me show you the difference. Here's what legal theory sounds like. The defendant owed a duty of care to the plaintiff. The defendant breached that duty by failing to maintain a safe premises. The breach was the proximate cause of the plaintiff's injuries. The plaintiff suffered damages as a result. Sound familiar? It should. That's what every law school teaches you and every CLE class repeats. And that's what most young plaintiff lawyers stand up and say in opening. And here's what happens when you say it to a jury. Nothing. They hear it, and they process it the same way you process a terms of service agreement when you're installing new software. They nod, and then they forget every word. Here's why. Legal theory tells jurors what the law requires. But jurors don't decide cases based on what the law requires. Jurors decide cases based on what feels right, on who they believe, on whether someone broke a rule that they already care about. Legal theory is like a checklist. It's abstract. It has no heart. And an emotionless case gets an emotionless verdict. I've seen lawyers with airtight legal arguments and good facts that get defense verdicts, or sometimes even more disheartening, get a plaintiff verdict but a very low number. Every element was satisfied, every box was checked, but the jury didn't feel anything. Because duty, breach, causation, damages, those are chapters in your torts textbook. They're not a story. And humans decide with stories. Jurors don't want to know what the law says. They're asking what happened here and who's responsible. And that's where your theme comes in. A theme is the emotional and narrative core of your case. The one-sentence story about why the defendant's choice violated a rule your jurors already believe in. Let me give you an example. Let's take a rear-end car crash. The defendant was texting, rear-ends a woman, and stopped at a stoplight. She's got a herniated disc, can't work. This is how the legal theory sounds. The defendant was negligent in that he failed to maintain a proper lookout, breached his duty of care, and proximately caused the plaintiff's injuries. Okay, that's legally correct, and you've probably already forgotten half of what I just said. Now let's look at it with the theme as the central core of your opening statement. He chose his phone over the road, and that 5-second choice cost her the career she spent 15 years building. Do you feel the difference? You hear that and you know what happened. The theme doesn't mention negligence, doesn't mention duty or proximate cause. It tells you what happened in human terms. It names the choice, it names the cost, and it points at the unwritten rule every juror already believes. You don't look at your phone when you're driving. That's a theme. Here's how you know you have one. A real theme has 4 qualities. First, it is simple. 15 words or less, easy to understand. If you can't say it in one sentence, it's not a theme yet. Second, it's universal. It connects to a value everyone in the courtroom already shares. Not a legal standard, a human standard. Third, it's repeatable. You can say it in opening, you can reinforce it through witness testimony, and then you bring it home in closing. It doesn't sound forced in any of those situations. And lastly, it fits the facts. You're not stretching, you're not forcing the case into a box because it sounds good. The theme naturally explains what happened. Now, if you've hit all 4, you've got your theme. Great. If you've only got 3, then you need to refine it a little bit and work on it. If you have 2 or less, start over. Because a weak theme is actually worse than no theme at all. A weak theme confuses the jury about what the case is really about and can lead them down the wrong path. Think about a recent case you've had. Can you say what it's about in one sentence without using any legal terms? Now let me show you this side by side. Same case, 2 different lawyers' approaches. Here's a slip and fall. Woman walks into a grocery store. There's water on the floor near the produce section. It's been there for 30 minutes. No cone, no cleanup. She slips, falls, tears a rotator cuff, and needs surgery. First, let's look at lawyer A, who leads with legal theory. Ladies and gentlemen, the defendant grocery store owed a duty of care to its customers to maintain a safe premises. The evidence will show that a hazardous condition existed, water on the floor, and that the defendant knew or should have known about the condition and failed to take reasonable steps to remedy it. This breach of the duty of care was the proximate cause of the plaintiff's injuries. Technically, legally, perfect. Legally sound, and the jury is already thinking about what they're having for lunch after they've heard that. Now look at lawyer B's approach, who leads with theme, who lets the theme guide what they say in their opening. For 30 minutes, water sat on that floor. Employees walked past it. Nobody put down a cone. Nobody grabbed a mop. They knew it was there, and they decided it wasn't worth the trouble. And that decision is why Linda is here today. Same facts, same evidence, same witnesses, but lawyer B told the jury something they can hold on to, a story about choice, a story that knew about danger and decided to ignore it, an unwritten rule every juror believes: if you see a hazard, you fix it. They knew and they ignored it. That's a theme, and it does something legal theory never can. It makes the jury angry. Not sympathetic, not understanding, angry. And plaintiffs actually do like a jury when it's angry, particularly at the defendant. You might think that you want sympathy from the jury. Sympathy gets you a polite verdict. Anger gets you the verdict your client deserves. Jurors who feel anger think that wasn't right, they need to pay for that. And here's the part that most lawyers miss. Jurors decide on theme before they decide on legal elements. They know who they believe and who they're angry at long before the judge reads the jury instructions. The jury instructions just give them the legal permission to do what they've already kind of decided what they want to do. So here's the bottom line. If you're standing in front of a jury and leading with duty, breach, causation, damages, you're giving them a law school lecture when they need a story, and you're probably going to lose. Legal theory keeps your case alive. The theme is what wins it. And if you want to go deeper on finding a theme that actually moves juries, I do work with plaintiffs' lawyers one-on-one on a limited basis. The link is in the description. So now you know what a theme is. But knowing what it is and actually finding one for your case are 2 completely different problems. Most lawyers sit down with their file and try to brainstorm a theme. They stare at facts, they overthink it. They end up with something that sounds good on paper, but falls flat in the courtroom. And there's a better and faster way. One question that you can ask yourself that cuts straight to the theme every time. And if you want to know what that is and how it works, then you need to watch this video next.